we refer to two decisions. The first decision is advisory opinion number 2 of 2013, and we have set out the analysis in our case digest. Your Ladyship, this decision concerned the interpretation of the applicability of Article 110(3) on the Division of Revenue Bill, which action was before the Supreme Court. Your Lordship, the court was emphatic in this matter, and I want to refer to paragraph 141, where the court was emphatic that it is quite clear, though some of the counsel appearing before us may have overlooked this, that the business of considering or passing any bill, and emphasis here, Your Ladyship, is bill, any bill, is not to be embarked upon and concluded before the two chambers acting through their speakers address and find an answer for a certain particular question. And then the court proceeds. What is the nature of the bill in question? The two speakers in answering that question must settle three questions. First, before a bill is published, they must go through the motions of debate, passage, and final assent by the President. The questions are, is it a bill concerning the county government? If it is it a special or ordinary bill? Then the court proceeded, Your Ladyship, to find as follows, that if it is not a bill concerning the county government, is it a money bill? It is only after that process that the speakers then, whilst answering these questions, proceed to know where the bill falls and to know where the bill is then placed, whether it is debated in the National Assembly or whether it is debated in the National Assembly and in Senate, if it touches and concerns county governments. It is peradventure, Your Ladyship, that the 24 bills we referred to and that were the subject of the proceedings in the High Court and the Court of Appeal were not or did not meet the test of Article 110, Subarticle 3. Sadly, Your Ladyship, the Court of Appeal, in its misdirection, distinguished erroneously the decision in the matter of Speaker of Senate as a decision applying specifically to the Division of Revenue Bill. For that misdirection only, Your Ladyship, the judgment of the Court of Appeal must be set aside. The Court of Appeal should have read into the classification by the Supreme Court that Article 110, Subarticle 3 apply to all bills and not only to the Division of Revenue Bill. Your Ladyships and my Lords, it is instructive, again, that this decision was made available to the Speaker of the National Assembly. But Your Ladyship, let me go further and confirm that this court has dealt with any legislative concerns touching on Parliament in the matter of the Interim Electoral Commission, Supreme Court reference number 3 of 2019, where the court, whilst dealing with the term Parliament in its legislative duty, underlined, Your Ladyship, that whilst Article 95 and 96 sets out the role of the National Assembly and Senate in their legislative duties, there are several overlaps in these functions. And therefore, the court underlined that legislative duty incorporates both houses where there are several legislative overlaps. And whenever there's a reference to Parliament, then any bill where any reference is made to Parliament in any undertaking, Your Ladyship, for instance, in approvals, then Parliament must mean both houses. The intention originally, Your Ladyship and my Lords, was that the Senate would be the upper house, a house of wise women and men. And I think that has come to pass, they're wise. The leadership, let me submit further that this court has gone further after the filing of this petition. In its decision in petition number 1 of 2018, which is the Institute for Social Accountability and the National Assembly and others, the CDF decision, this court again, whilst declaring the CDF Act 2015 unconstitutional, again went to the same interpretation. At paragraph 71 of the decision of this court, the court found at paragraph 75 that we agree with the reasoning adopted by the High Court that while the concurrence of speakers is significant in terms of satisfying the requirement of Article 110(3) of the Constitution, it does not by itself oust the power of this court vested in Article 165(3)(d), where a question regarding the true nature of legislation in respect of 110(1) is raised. And that was the submission. The mandatory provision still allows the court to evaluate. In this case, your leadership, the court evaluated the intent and import of the CDF Act 2013 and found that the CDF Act covered questions that touched on counties and was enacted without the participation of the